Hi. Hello, everyone. We need to start, so can you please grab a seat? We need to start. Everyone, please grab a seat. Everyone, can you please grab a seat? We need to start. Yeah, can you go around and tell people? Yeah. Everyone, can you please get seated? We need to start. 라이브 스트리밍. Everyone, can you please get seated? Okay, everyone. Thank you for coming today. My name is Toku, and I'm the co-founder of Qlay Technologies. And so before we get started, I'd like to quickly introduce Qlay to you guys. We're one of the hosts for this event. So basically, Qlay was founded by these two founders. I'm the guy to the right. And what we do is we're building these AI proctor tools that catch, basically for online interviews, that catch candidates when they try to cheat using AI tools such as ChatGPT and Qlay and a bunch of other tools. And so basically we do that via various mechanisms. So we do eye gaze tracking, we do speech cadence analyses, and we do multi-camera views. The other view is from the candidate's smartphone, and we do real-time object detection using edge computing to make sure only the objects that should be there, are there, and such as there shouldn't be like an extra iPad next to the computer, for example. And so we're based in San Francisco, and we host a lot of events. So these are a couple of events that are coming up next week. These are official events that are part of the A16Z's SF Tech Week. So on October 7th, we have an event called AI Talks and Demo Night. We're co-hosting this with Agora. And we have speakers from Google Maps, from AWS, and from Salesforce. And then we have another event on October 8th with Upscale X. They are a seed accelerator that invests like $1 million into startups. And we have an agentic commerce night with them. So both of these are going to be in downtown San Francisco in our office. And I also want to talk about Digital Garage, one of our investors. They run this seed accelerator program called Open Network Lab. They have 2 batches every year. They're based in Japan, but they accept applications from all over the world, and they invest $100K into startups that get accepted into the program. And also, kind of using our AI proctoring tools, we also run this engineer hiring, like talent marketplace. And so if you're interested in hiring global engineers remotely and kind of, which helps keep your your burn rate low, you can come reach out to us. And as sort of whenever we host these events, we run these campaigns where if you book a call within the next 48 hours, you get 400 free engineering hours. And so yeah, today's event is about artificial intelligence and patent law. We have a couple of great speakers. Actually, Stephen Ho, actually, I've known him since my freshman year at MIT. We were actually living in the same dorm, and yeah, we've known each other for a long time. And so I guess I'll hand the mic over to these guys now.
Hi, everyone. Good evening. Thanks for So the topic, as mentioned, artificial intelligence and intellectual property. So the idea was here to not get into the law aspect of it, but talk about, as we are talking to most of the few as, startup owners, investors, how does it really the AI, which is a buzzword these days, impacts when it comes to, you are trying to go for intellectual property protection. So to start with, you all know that the inventorship was pretty much with the humans, and as the journey shows, we started with the humans creating, craft, science, and engineering, tools. Then we went into software era where we started using some kind of tools like CAD and other simulation tools to develop stuff. And then we entered into a era which is AI assisted. So that's where still there was no problem. There was some problem when it came to 101, where we talked about software cannot be patented. There are issues where a mental step cannot be protected, stuff like that. But that is kind of still settling down. The problem now is where we are talking about actually, where AI has become itself so much capable on its own that it is creating something which is not needing human intervention at all. So this is the point where the law at present is kind of not pretty much settled, I would say, across the globe. We are still figuring out ways to tell people when you reach out to us what to protect, what can be protected, or what is something which cannot be protected. But there are some pointers which I have stated out here, and we can look at that and probably follow some of them to be on the safer side. I still say pretty much that it's not settled, but we do have some options to go ahead with. So why it is important for you guys, you pretty much understand that the first question, when you go to an investor, the thing that comes into his mind is who owns the IP? So if it is not an AI scenario, or if it is a scenario where you are not very clear that what part of your invention is actually being controlled or it's being controlled by AI and what part of it involves human intervention, then you may not be able to answer that very clearly, and that creates a doubt with the VCs whether you have the right of the invention in your hand or not. The second thing is when you're not clear, so the strategy, which is basically if there is something that you can protect with, let's say, patents, and if there is something that you can protect with trademarks, and if there's something which you can protect with copyrights, and there's something which you can protect with just trade secrets, you may not file anything, but just you keep it as secret. So you need to have a right strategy to make sure that you don't end up losing your rights, because most of the time we talk about filing patents, but we forget about the rest of the piece, which can also help you in getting that protection. Then, as we said, the legal uncertainty is pretty much there across the globe. We don't know up to what extent we can say this can be, get passed through the PTO offices, and this cannot pass through. So that uncertainty remains as a challenge for startups, and the jurisdictions are themselves not clear. So we talk about a part where we have to keep in mind when we are dealing with AI assisted and AI generated. So if it is AI generated, we are talking about something which is no patents or no rights, I would say. We have in control, where we will probably have to think about other means like trade secret to keep things secret. If it is AI assisted, it remains the same as it has been. You just file an application, you file a registration for your design, you file a copyright protection, and you are good to go on that. I've just taken some examples. The green says it is patentable, but I would modify it as maybe patentable, because it is certainly not very, very clear at different jurisdictions whether we can really call it out as patentable or not. So the first example, it says AI suggests 50 designs, human selects and refines the best option. So it is talking about AI being utilized as an optimizing factor rather than AI itself being innovator or creating a solution or a result out of that. On the other hand, if you're talking about the two examples below, so we are seeing AI independently doing, let's say, a novel quantum circuit architecture preparation, or AI independently discovering a novel deep learning learning architecture. So if that is a scenario where you are developing your product, there is a doubt. You may consult your legal guy. Well, what should we do? Should we really go for patenting, or should we talk about trademarks, or should we talk about copyrights, or should we talk about trade secrets? So many a times you might get that answer that, okay, let's just keep it as a trade secret. And the burden will be on us for sure that we have to keep the thing confidential. So that's just to give you a hint on something which could be patented or something which may not be. But as I said, it's a maybe thing based on the jurisdiction. One thing which I just wanted to bring to your notice, which was a case, very famous case, where somebody filed a patent in the name of an inventor. The inventor here was not a human being, but AI itself. And the result was that most of the jurisdictions, they rejected the application itself. There was one jurisdiction which actually accepted that, but that was just accepting the application, not examining the application. So the state as of now, it still remains the same, where if you call out AI to be your inventor per se, you may be in trouble. So that is one liner, which is, let's not call out AI as inventor, and let's make sure that we record all the human contributions in the development process, where we can really, if asked, when you're applying for an application, if asked, you are able to state where and how the human contribution gets into picture. So if you have that ready, you are pretty much kind of settled while talking to the examiner and getting a patent application. So based on those comments, one of the key takeaways is it's still human-centric, the patent system. AI still remains just a tool, and there is a big gap in law in terms of what can be patentable and what cannot. So we can take this as a pointer and move ahead and probably do these actions as startup owners. So what is the first one, as I was talking about? Document human contribution. So which helps you in justifying that it is not purely AI-driven development, or it is not purely AI-driven innovation. So that's kind of a very, very important step throughout your development. You can ask your team, yourself, that you have this aspect in control. The second one, as I was talking about, think about not just patents, but other means to protect your innovation, so that you still have the rights in your hand. And if you're talking to an investor, or if you're talking to somebody where you want to showcase that your invention is in your control, you use those methods. So it could be trade secret, trademark, or other methods. Contract clarity. This also tells, when we are talking about, there are multi-parties involved. You're using somebody's cloud, you're using somebody's AI model, you're using something your own. So who owns what? Who is the party who has the control on the different aspect of the system? So that gives you also an edge. Okay, I own what piece of the invention. So having a contract clarity would kind of will make your life easier when you're talking about AI-driven inventions. And as I said, human inventors, no. So some checklist with the AI. So if you're talking about patents, name humans, keep contribution logs, copyrights, protect human modified work. So just to bring you a story which probably relates to 2011-12, where I think probably many of you might be aware of that case, where there was a photograph which was taken by a monkey itself. So it was a monkey, selfie, as it was called out. Now, funny thing that the photographer, he went after Wikipedia because Wikipedia posted those photographs out there in their gallery as a public, information. And there was a big conflict, with Wikipedia, where he said, you are trying to use my intellectual property because I made the whole scenario so that the monkey could take a selfie. Even in California, the case was filed by PETA organization, where they claim that the right should be with the monkey who actually, has taken that picture. So you can think of that as an example with the scenario we are talking about when you're talking about AI. So the ownership, the burden on proving that you have your control will purely be based on what type of intellectual property you guys have considered, and whether you have the required logs or evidences or not. Trademark, it's pretty much settled because it's for commercial use. So if you're using it commercially, even though if you have used AI to generate something, which is a logo or a brand name, whatever, it's perfect if you register it and you're using it. So there is no challenge out there. Contracts, as I said, so define the role clarity when it comes to vendor and partner. Again, reiterating just for your knowledge, if you're talking about patents, if it is AI assisted, we are fine if it is human inventor involved in the process. If it is AI generated purely, it's a no. Copyright, same way. We're talking about human edited, protectable. And if it is not so, it is AI generated purely, we are saying it's no protection. Trade secrets, it's perfectly fine till the time you keep it as secret and it is enforceable. And trademark, as I said, if you're using it and you have registered it, even though you have used AI to get the mark done, no problem. Another aspect which is also being discussed because AI is involved into innovation. So if you are using AI and you have taken only the assistance, which is basically tools, you can think about having a patent and then probably asserting it on others. If that is not the scenario, you are probably in a situation where you may not be able to assert or do an infringement action. Copyright, if it is your own work, again, you can talk about assertion or infringement. If it is not so, you are not in control of that. And trade secrets and trademark, it's pretty much open. So in infringement scenario, the trouble is, if it is not very clear that who owns the piece of, the key piece of the invention, we don't have a patent in hand. And once we don't have a patent in hand, we cannot enforce it. So that remains a trouble. And there are situations where people are still discussing about who owns the responsibility if AI infringes, something. So is it going to be the person who owns it, or is it going to be the middleman who owns it, or is it going to be the infrastructure as a whole who owns it? So it's a debate, and I would say to be on the safer side, have the logs and make sure you have a patent in hand so that you can assert your patent and you have the right to make sure that people, if you want to use them against people or want to stop them, you can tell them to, that you have the patent in hand. So as I was talking in the beginning, that the scenario right now, because of AI, it's a change, it's a shift that we all have to follow. We not rely on patent per se, but have a mixed strategy. So you have patents for something, you have trade secrets for something, and you have trademarks for something. It's a bit of a expense in the beginning, but this gives you a clear path that you're safe and you have your IP in hand in a better way. So last pointer which I wanted to talk here is that it's a blurring a boundary. We don't know where it is going to end. The legal world is still brainstorming on it. The PTOs are still brainstorming on it. So probably the current state, human has to be there if you want to patent something. Otherwise, it's no. And the AI generated content, if it is, whether it is a copyright or whether it is a patent, it's not protectable. And founders need to have a mixed IP strategy. And finally, maybe in time from now, maybe next year by now, you might have some cases in court, as it happens in US usually. You may have a decision which might really give you a clarity on what to do when you have AI as a major piece in your invention. This is just about my firm. This is what we do as a service. We are a patent prosecution as well as licensing services company based in Chicago, Buffalo Grove. In case if you need more information, happy to share on that. We also provide trademarks and copyright solutions. So if there is a need, happy to share more information on that. So that's a quick one from my side. I will hand over to Stephen to take the next piece of IP itself so that he can continue, and maybe we can have a Q&A after that session. Please, Stephen.
All right, so I'm Stephen Ho from the American Patent Agency. So our firm focuses on patent prosecution, drafting, patent counseling for a wide variety of technologies, blockchain, robotics, AI, semiconductors. Although these days over 80% is in AI, which of course is where all the funding is. So to kind of just as a standard disclaimer, this lecture is strictly educational. All right, so please don't think of this as legal advice, and we're not liable for any actions that you may take from this. So this is just to protect ourselves. All right, so the next slide, this one, I just listed some of the ways in which AI is affecting patent law today, right? And of course, it's the AI as an inventor, that's the one that a lot of entrepreneurs are currently thinking about. So just so that I have a sense for who the audience is, how many of you are working in AI to some extent? Okay. And how many of you are founders or executives of a startup? How many of you are working at medium-sized companies, larger companies? Okay. How many of you are just for fun? Any attorneys here? Just to get a sense. Okay. Do you guys specialize in IP or other areas? Okay, it's a mix too. All right, great. So the first one, this is the one that I do the most in my practice, right? AI is part of an invention, right? This is what people are trying to get patents on. The next one is AI as a tool used in the as an aid in the invention process. That's what Rajesh had talked about quite a bit in his last section. So I'm going to elaborate on that point a little bit more. The next step, of course, is AI as an inventor, right? Rajesh, he distinguished between AI-generated inventions, right? That would be AI as an inventor, as opposed to AI-assisted, which is AI simply just a tool. The next step is what happens if AI becomes the owner of patents, right? And of course, this carries over into other areas of the law, right? Because AI doesn't have a legal personality, right? AI cannot have a bank account or own property, but that might change at one point. The others are a little bit more technical, but for example, in patent law, there's this concept called a person having ordinary skill in the art, right? And that's a legal standard that appears in several aspects of patent law. For example, in order for your invention to be patentable, right, not only does it have to be novel, but also has to be non-obvious. But non-obvious to whom? It's non-obvious to a person having ordinary skill in the art, right? So someone else in that same field of technology, would it be obvious to that person? The other place where this comes up is when you're drafting patent applications. What is the level of detail that you need to do? Do you have to write a whole SOP about every aspect of how you make and use the invention? You only have to disclose as much information so that it enables a person having ordinary skill in the art, right, a FOCITA, to make and use the invention without undue experimentation. So are we considering AI as part of the standard toolkit that a FOCITA would have? And this would affect the standard in two ways, because what if a standard chemist, for example, today, has access to AI that a chemist 20 years ago did not? Then what would be obvious to a chemist, an AI-augmented chemist today, it would not have been obvious to that same chemist 20 years ago, right? So it'd be harder to get inventions to overcome that non-obviousness barrier if a typical FOCITA in that field has access to AI. But it also means it's easier to draft patents too, right? Because if everyone else has AI, maybe your patent application only needs to discuss a few prompts. Oh yeah, this is how you get your AI to be able to make this invention, right? So it's a double-edged sword there. The next one, AI as a patent drafter. I know there's a lot of tools out there, right? Talked to one guy in the audience today who's working on that. And now there's AI pretty much for all aspects of legal tech, right? It's a fast-growing field. Rajesh and I were just at a conference earlier this week, the International Intellectual Property Law Association conference. And one of the speakers mentioned that by his count, there's over 30 tools now, right? Just AI for patent drafting alone. And then there's others in other aspects of IP. So there's going to be a lot of winners and losers, just like in any other very competitive space. and it remains to be seen how that's going to go. AI is a generator of prior art. This is a topic that one of my interns, Andrew, and I had written an article about, which is, as you know, you can't get a patent on something that already exists out there in prior art, right? So if somebody publishes an invention, puts it out there on the internet, and then someone else later on independently invents the same thing, they cannot get a patent on it, right? Because the first person had already conceived of the idea and released it to the public. What happens if you just want to basically block everybody else? So you create this AI that just spews a whole bunch of ideas and just posts it on the internet, right? Now, even though you're not trying to get a patent on it, but you're just blocking everybody else from innovating, right? And now it's AI-generated content is basically flooding the internet already, right? This could affect patent law in this way. AI as a prior art searcher and examiner. This is already happening, right? There's a lot of patent offices out there. For example, the Korean Intellectual Property Office, one of the most innovative countries in the world, they are now adopting more and more AI as part of their standard processes. The United States Patent and Trademark Office is now also implementing AI solutions for their examiners. Right now, it's AI enhanced examination, but what happens if 5-10 years from now, even human examiners have been superseded, right? And then finally, and this is another topic that Rajesh touched upon, is AI as an infringer. And again, this crosses other areas of the law too. For example, tort liability, right? Most obvious example is when you have a self-driving car and then that car hits and injures somebody, who is liable, right? Is it the owner of that car? Or is it the software developer who then developed that AI? Or is it the person who trained that AI with bad data, right? There's a lot of potential questions out there. And the same thing is true for AI as an infringer, right? Suppose I have a company, and then my company, I have all these AI agents. Everyone is using agentic AI now, right? What if your AI agent does something and starts infringing other people's patents? And then you get sued. What's going to be your defense? Oh, that wasn't me. That was my AI agent, right? So it remains to be seen how these kinds of scenarios play out in the real world. So I know maybe from far away, this text may be kind of small, but I listed here a timeline over the past 4 years or so about what are the most important changes in AI patent law, right, around the world. So IP5, that stands for the 5 largest patent offices around the world. That's the United States, the European Patent Office, China, Japan, and South Korea, right? And a lot of this had focused on disclosure requirements as well as inventorship, which means what happens if you want to get a patent on an invention directed towards AI? What exactly you have to disclose, right? And then the other is, of course, inventorship. What happens when a human scientist or engineer is using AI as part of the conception process, right? Where do we draw the line, right? And that's an area where, at least for now, all 5 major patent offices have come to agreements on this. So even before we get into the whole AI stuff, we have to understand what is the standard for inventorship on a patent, right? A lot of people, and I give this talk to people in academia all the time, and they always have this question, like, oh yeah, I was a co-author of that paper, right? In fact, I was first author, second author, and yet I'm not listed as an inventor on the corresponding patent application for that technology. Why is that? And the reason is that the standards are actually different, right? For those of you who are in academia, paper authorship can be very, wishy-washy, can be kind of, it could be by custom, right? Maybe everyone who had some hand in doing the experimentation is involved. Maybe the top dog in the lab is always on every paper, even though he or she did not actually do any data analysis or was even present for the experimentation, right? Whereas patent inventorship is a very clear standard determined by law. And what is that? So to be considered an inventor on a patent, the person must have contributed to the conception of the idea of the claimed invention, right? And the MPP, that stands for the Manual for Patent Examining Procedure. So that is a regulatory guidebook, essentially, for examiners in the patent office. And it covers pretty much every rule that you can think of. And this is the idea, this is the legal definition of conception, right, according to US patent law. It's the formation in the inventor's mind of a definite and permanent idea of the invention, including every feature of the subject matter sought to be patented. So you can't just come up with a generic idea like, oh, I'm gonna have this idea for like a new material for solar cells or something. you actually have to have the actual chemical formula, right, and the structure of this material in your mind, or at least on paper, right, for it to be considered, okay, this is the date on which it was conceived. Okay. And this note 1 that I have here, this is something a lot of inventors are actually surprised about, which is an inventor actually does not need to know that the invention will work in order for conception to be complete. He or she only needs to show that they had the idea. Right? So it is possible for you to come up with an idea and then only later verify or even believe that it's going to work. And yet conception is when you first came up with that idea. Right? Okay. So this joint inventor idea is of course going to be very important when we talk about AI, right? Because people are thinking, well, yeah, I didn't come up with the whole idea because I collaborated with my AI, so we should be joint inventors, right? That's the question that a lot of people are trying to think about. So the post-1984 rule for this is relatively loose. As long as someone contributed to at least one feature of one claim, they are counted as a co-inventor on that patent. And I know that might seem very unfair because there's been a lot of situations where you have 3 people who've been working many years on this invention, and at one point they had a meeting where some 4th person walked into the room, threw in some idea, and then that idea ended up in a patent claim, right? No matter how minor or how little time that 4th person spent, if that idea ended up in one of the claim features of a claim, they have to be listed as an equal co-inventor on the patent application, right? That's how it works. Of course, they can make contracts between themselves or within the company as to, percentage shares of royalties and stuff like that. That's totally negotiable. But at least for the purposes of determining who is an inventor and who's not, it's a very black and white when it just comes to, did you contribute conceptually to one feature of one claim, right? Okay. Oh yeah, before that, I also want to mention that the important part is that it has to be a conceptual contribution. It cannot merely be building. So if I come up with an idea, but then I hire a technician to actually build a prototype, that technician would not be considered a co-inventor, okay? But if my idea was too vague, and then my contractor then had to do a lot of tweaks and experimentation on their own without my direction, and then those ideas ended up in the claims, now it becomes a co-inventorship scenario. Does that make sense? So that analysis becomes important when we think about artificial intelligence. So obviously, when you read the news, there's always going to be AI anywhere, so I know I don't have to tell this audience that. This is the case that Rajesh was bringing up, right? This is probably the most famous set of cases around the world today when it comes to AI patent law. It's the Davis case. So I'm going to jump into that a little bit. So here's the history behind this. There's a physicist, Stephen Thaler. He created a series of neural networks, which he called DABUS. You can look at the acronym here. And he actually listed DABUS as an inventor on a bunch of patents directed towards ideas that DABUS created, right? So let's be clear. So Stephen Thaler, he did not actually invent things. He only invented this AI, but then the AI invented a bunch of things, right? And you have to give it up for Dr. Thaler because he didn't try to claim this. He didn't pretend that the AI didn't exist and simply just file these patent applications under his own name, right? He actually got, excuse me, he listed the AI as the inventor, but he listed himself as the applicant, as the owner, because he says that he owns the AI, right? And this is typical, right? For most people, if you work at a company, it's the employee who gets listed as the inventor, but it's the employer who gets listed as the applicant and the owner of the IP, right? So if you work for Apple, Google, Novartis, whatever, they are the applicant, right? And the owner of the patent. You as the employee, you are the inventor, right? So he was trying to get his AI recognized as the inventor, but then himself as the owner of the AI, as the applicant and owner of the IP that the AI generates. So this went through the patent office. The patent office rejected it. He then sued the patent office. That went to federal court. And it went up to the federal circuit, which is the appellate court in the United States, right before the United States Supreme Court. And they rejected his arguments. They said, inventors must be humans, right? This was back in August of 2022. And he appealed to the Supreme Court of the United States, which then denied cert. So the federal circuit decision still stands today. And as in reaction to this, the United States Patent Office, Patent and Trademark Office actually released inventorship guidelines. And I encourage all of you to look at this. So if you look at February 2024, USPTO inventorship guidelines, they actually lay out some of the rules that are still standing today about how do you determine AI inventorship. So what is the state of the law right now? Pretty much every jurisdiction around the world that has looked into this case, because remember Stephen Thaler, he basically sued patent offices all over the world, right, about this case, and he lost every single one, except for one. But so Australia, they briefly recognized Davis as an inventor, but then the decision was later overturned. South Africa is currently the only jurisdiction that recognizes AI as an inventor. Okay, this might change. Who knows? Maybe when we give this talk next year, things will be different. But that's where we stand right now. So, what are some of the arguments? I'm sure a lot of you have thought about how AI will affect technology and work and all that kind of stuff. All of those same ideas apply to patents as well, right? So currently, AI is still generally merely a research tool used by a human inventor, but now we're obviously moving beyond that, right? So the argument in favor of AI as inventor is, although humans built the AI, the humans did not conceive the ideas. The AI did. So why should the human being get credit, right, as the inventor? So very few people are actually making the argument that a human who just passively, owns an AI or even prompts an AI no one is saying that the human should be an inventor, right? The two arguments are either the AI is a sole inventor or co-inventor, or nobody's the inventor, right? And then we're going to see that right now the rule is if you have a human scientist or engineer who then builds an AI, and then that AI invents stuff like Dr. Thaler did, the situation is that no one is considered the inventor of the IP, which means that nobody owns that IP, right? So that means that the default sort of scenario for protecting this would be trade secrecy, right? So we think what a lot of people end up doing is they'll be building AIs that then invent things, but then they'll just simply keep that information a trade secret, right? Because they can't get a patent on it, so the next best thing would be try to keep it a trade secret. One of the fastest growing areas of AI right now is innovation in other fields, right? We've already seen this in drug discovery, chemistry, physics, and other areas too. And this is, of course, one of the, this is recognized in the 2024 Nobel Prize in Chemistry, right? Where Google DeepMind created AlphaFold, an AI model that predicts protein structures from their amino acid sequencing, right? So this is a huge advance in the field of chemistry, but obviously also in artificial intelligence as well. So then what happens if AI becomes so good at science that no human can ever beat an AI when it comes to fundamental scientific discovery, right? Are we gonna start recognizing AI as winning Nobel Prizes, right? Who knows, right? Okay. And there's a lot of articles out there. I listed one of them here. There's a lot of people out there who are writing about what people meaning scientists, should or should not do in terms of prompting AI to help them make inventions so they avoid some of these issues. So we talked about this a little bit, right? The distinction between inventorship and ownership. An inventor is the human being who actually conceived of the idea, but then the owner of the IP is the one who actually holds those IP rights. By default, it's the same, right? If I'm just a random guy, unemployed, invent something, I'm not only the inventor, but I'm also the owner, right? But most inventors are also employed somewhere, so then it's their employer who then typically owns that IP. So inventorship can never change, right? But of course, ownership can. Just like if I am architect of a house, I'm always going to be recognized as the architect of that house, right? But then the owner of that house can, of course, change as people buy and sell that house. So a broader question, and Rajesh mentioned this with the monkey selfie case, which I'll talk about in the next few slides, is what is the state of the law when a non-human entities generate IP, right? So that's the question. Of course, this talk is geared towards patents, but then it's highly related to other areas of intellectual property, right? Copyrights, trademarks, and trade secrets. So let's talk about this monkey selfie case because everyone loves it. It's a nice photo too. So here's the background behind this. 2011, British photographer David Slater, he went to Indonesia, right, taking nice nature photos. And he had set up his camera so that it would take photos. And at one point, there was a macaque monkey named Naruto. he actually took the camera and snapped selfies of himself, right? That becomes actually a key point. And Slater then published a book that included these monkey selfies. So PETA, the People for Ethical Treatment of Animals, they actually filed a US federal lawsuit claiming that the monkey's copyright of the images had been violated, right? So that was the case. That was what was going on, right? So we see the argument on both sides. So what did the US court say? They said that Naruto has no standing to sue, first of all, because he's not a person, right? He's not even any kind of legal entity. So they kind of split the difference here. This is the conclusion. Slater does not own the photographs because he did not take them, right? He did not actually take the photo of the monkey. He just simply made the camera available, and then the monkey actually pressed the shutter, right, and took a photo. But the Naruto also doesn't own the copyright either because he's not a person. So they kind of split the decision in the middle, right? And as a gesture of goodwill, Slater agreed to donate 25% of the revenues generated by the images to support, conservation in Indonesia. So, how many of you heard of this case before today? Okay, yeah. When Rajesh and I were at the conference earlier this week, the lawyer who was part of the case actually talked about it. So I thought that was pretty exciting. Okay. So I showed this slide earlier, but I wanted to highlight one thing, which is the February 2024 inventorship guidance. So I'm going to go over those principles briefly. So this was pursuant to President Biden's order on basically making sure that we have some more clarity on AI when it comes to U.S. federal law, specifically when it comes to patents and national security. And there's also areas outside of inventorship guidance that were covered in the same guidance. These are a little bit more interesting to patent attorneys and patent agents and other people directly involved in the process, but it's helpful as well. I listed them here. One of the more important ones is the duty of disclosure and duty of reasonable inquiry. So if you did use AI as part of your inventive process, do you have to disclose that to the patent office? Right, so we're going to talk about what is the extent of that requirement. Okay. So first of all, the USPTO, they of course affirmed the Federal Circuit's Thaler decision, right? Only a natural person can be an inventor, so AI cannot be. Okay. So the analysis then becomes, did a natural person significantly contribute to the invention, right? And it's determined case by case. So the US Patent Office, they don't like making up new rules, right? Just out of nowhere. That's not their job, right? It's Congress who has the job to make the laws, and then theoretically, the courts are supposed to interpret those, right? But, okay. So the Federal Circuit, they look back on one of their older cases when it comes to human joint inventorship, and then they try to extrapolate those same principles to what happens if one of those humans is now swapped with AI. So here's the rules. An inventor must contribute in some significant manner to the conception or reduction of practice of the invention. They must make a contribution that is not insignificant in quality when that contribution is measured against the dimension of the full invention, and it must do more than merely explain well-known concepts or the current state of the art. Okay, so you're thinking, okay, this is just a little bit more detail, but what exactly does this mean, right? So the guidance recognized 5 major principles. I listed them here. And you can go online and look at it yourself, but they list them. I'll just make a few commentary about each one. So the first one is that, first of all, AI assistance is allowed, right? The US Patent Office isn't saying that as soon as you use AI, now this is not patentable anymore. They're not saying that. But merely recognizing a problem is insufficient. So you can't be like, oh yeah, I noticed that it's too difficult to make an alloy out of these 2 metals, right? And then you ask your AI to try to figure it out. That's not enough. Reduction to practice is also insufficient. So just having a working solution is also not sufficient. You actually have to describe the steps needed to make this happen. Developing an essential building block may be sufficient. What if along this whole process of making the solution, there is one essential step that only you could do? Maybe the AI did other parts, but you did that. That might be good. And then the last one, ownership or oversight of an AI system is insufficient. So this is what they call intellectual domination or something like that. And that's not sufficient for inventorship. If you have time, I do encourage you to check out the 2 hypothetical examples that the USPTO published on this, because they wanted people to have examples about what they mean by this. And they have 2. One of them is in mechanical engineering. So this is one where a bunch of inventors created a transaxle axle for a remote control car, and they have 5 hypothetical scenarios. So 3 of them, the USPTO said humans are not proper inventors, and you can see why those are. And then there's another 2 scenarios where the humans are proper inventors. So you can kind of see where that gray line would be once you go through the scenarios. The other one, by the way, how many of you are in biotech, like applying AI to biotech? Okay, all right, cool, some of you. So you might want to look at this. This one is really good. It's the development of a therapeutic compound for treating cancer, right? So what happens if you have a group of scientists who use AI to varying extents to then create therapies? And they also went through a couple of different combinations and aspects of usage of AI, where some of it is considered okay, other ones were not when it comes to inventorship. So what are the key takeaways of this? AI cannot be the sole inventor or even a co-inventor of a US patent, and most countries around the world now have the same rule. The use of AI in the conception or reduction to practice of invention does not negate a human inventorship. So it's okay to use AI and still list the humans as the sole inventors. But a natural person using an AI system is an inventor if the natural person makes a significant contribution to the invention as determined by the PANU standards for joint inventorship. So you have to dig into that guidance to see where that is. The next one, each claim of a patent must have a human inventor, right? So that means that if the patent office or the federal court determines that you have this one claim, wait a minute, I think an AI did this part, then that would have to be struck, right? Have to be either canceled or invalidated later. Okay. This is really interesting, this last one, and this is in contrast to the Copyright Office. The guidance did not state any requirement or duty to disclose to the USPTO that the inventor used AI as part of the invention process. And this is distinctly different from the US Copyright Office, where what happens if you use AIs to now generate images or music or other things, you want to get a copyright on that. You actually do have to disclose the usage of AI when it comes to copyright. Patents, for whatever reason, decided to go a different direction with that. There's a bunch of references that I had. I encourage some of you to look at this. If you just Google up USPTO AI-related resources, they actually have a page now that centralizes all of their resources and directives when it comes to AI and patents. And of course, a bit of self-promotion. We have some articles that we recently wrote on these sort of topics. The first one just summarizes what's the issue, what's the current state of the law around the world in the top 5 patent offices when it comes to what they say about AI inventions. It's a pretty good summary. And then this other one was co-authored by myself and one of my interns, which is what happens if you have AI that just spews out prior art to prevent other people from getting patents. So we've explored that topic as well. Okay. So with that, I will end here and answer and open the floor to questions. Thank you. Yep, you had it in.
Love the presentation.
Oh, sorry, here's the microphone.
Sorry. Thank you for the presentation, I really liked it. Quick question about strategy. Given that the patents generally takes about, 2 years to prosecute, give or take, and the AI is moving so fast, what's the strategy here in terms of, advising on whether patent is the right path to go if the technology is going to change?
Yeah, that's a great question. So it was, given that the patent process is relatively slow, right? It might take 1, 2, 3 years from filing to actual issuance of a patent. But then AI as a technology is moving so fast that it's possible that by the time you get your patent, the technology is already outdated or superseded by either yourself or somebody else, right? Is that your question? And then what should you do? Yeah, we deal with this on a daily basis, right? I get that question all the time. But it has to be done case by case, right? So it is true that maybe for some people, patents might not make sense because even if you were to get a patent 2 years from now, you will most likely be superseded by either your own R&D or someone else, right? That's always very possible. The other is that patents, we think of it as a hedge. We think of it as a possible tool to do something else, right? Because what percentage of patents are actually litigated or enforced? A very small percent. But it doesn't mean that they're useless. I mean, there are some useless patents out there. But for the most part, what the patents are doing is that they're enhancing the value of your company. And what we've seen lately is not only is innovation happening faster, but even M&A, mergers and acquisitions, for startups is also happening very quickly too. And that's also driven in part by what the perceived value of these companies are. And from our analysis, we found that patents can still play a really strong role in that. We've had some clients that were acquired in part because they had a strong IP portfolio. So it was more like a hedge, like just in case a lot of these technologies become important in the near term, we have that advantage, right? We still hear some investors, being concerned. Oh, wow, yeah, you have a great technology, but how do I know that some other person in their garage 3 months from now isn't going to come up with something better? To be honest, you don't know. But at the very least, I can protect what I have now as a hedge against the fact that maybe what if that doesn't happen? And this really does become a standard technology 2 years from now, right? So everything's always going to be a risk and a gamble when you invest this way, but that's what we've seen.
Great talk. Thanks for your time and your insights. So I had a question about the Thaler case. So let's say I'm an inventor, I develop a machine that makes perfectly sphere metal balls, let's say. And those can be used as ball bearings or whatever, right?
Yep.
And I claim those metal spheres, but they were made using my machine. So isn't that what Thaler did? He created a neural network that created inventions.
Yeah.
So could that neural network be called the machine? And
Okay, so I think there's a distinct, so just to repeat your question. So suppose you create an AI that makes some physical object, like perfectly spherical sphere balls that are much rounder and more perfect than any other current manufacturing process, right? And then now you would either want to use this in your own machines or license them to other people, right? This is a great hypo, by the way. So here's the difference between your scenario and Thaler's. Thaler's AI wasn't creating physical things. It was actually just generating the ideas, right? Mm-hmm. That's the difference there. So when it comes to your AI, I don't know. There's a lot of gray area here because what if you are the one who is developing the algorithm for some robotic manufacturing system to make perfect spheres? You're still the inventor on that, right? In that case, the AI in the robot manufacturing plant is simply a tool to actually implement that, right? So I think that is actually okay. Where you might run into trouble, though, is what if the AI is the one that's figuring out the manufacturing process to make that perfect sphere? That's where you would be in trouble, right? Yeah.
but even if that happens, wouldn't that be covered under I made the AI? So I mean, that was one of the goals of the AI is to uncover these or optimize the manufacturing process.
Right. Okay. So let's talk about the worst case scenario, right? You're a brilliant AI scientist. You made this AI that then figured out a process to make these perfect spheres. And then either the same AI or a different one is connected to some robotic assembly that actually does it. So that's the scenario, right? So here's the analysis. You're not an inventor, right, on this. You cannot get a patent on this. No one can, right? But you then own this whole thing. So you can do whatever you want with what this thing is. It's like a goose that's laying the golden eggs, right? You own that.
So you can use trade secrets or other things.
Exactly.
Okay.
Most people would then recommend that you just keep that as a trade secret.
Okay.
Thank you. So I think based on the presentation, I kind of think I know the answer to this, but just for clarity, I want to ask it anyway. What happens if you have several AIs collaborating with each other and coming up with ideas independently of what humans may do or how they may influence them? They are AIs' original ideas by interacting with one another, not independently as a group.
Good. So you're saying what happens if you have a bunch of AIs that collaborate and then generate ideas?
Right.
Okay. So there's a lot of issues to untangle there, right? So first of all, human beings, we're all individuals, all right? So it's pretty clear this is a person, that's a person, and so on. But with AI, that is so unclear, right? Because what if I have an AI system, then I copy that into something else? but then they get trained differently. Is that still the same? When you copy an AI, is it still the same AI? There's a lot of philosophical questions about that, right? So I would say that as long as you own all of these different aspects that are doing this, then you can do whatever you want with the IP that's generated. You still can't get a patent on it, right? Because then no one would own that IP itself. But then you could own whatever products that come out of that. I think the trickier issue, and then this is where contract law might come in, and we're already seeing this already, is what happens if you have two different companies that have different AI systems, and then they collaborate then to create things. This is an area where, this is why when people then enter into licensing agreements, when it comes to AI, they have to think about this in advance, right? Is if my, suppose I have some AI system, you have some amazing data set, we enter into agreement, then and it starts inventing stuff. Who owns the product, right? We would have to negotiate that. Yeah.
Thank you.
Thank you so much for a really interesting talk. You've spoken a lot about sort of AI as a potential inventor, but I think I also see the possibility for it just making it so much easier to do prior art and drafting these. I work in a company, we have more ideas than we can possibly file. I think we're looking at the possibility of the cost of drafting and filing these coming way down. And it's just flooding the patent office. Like, how do you think about this changing the way we practice intellectual property and how that changes?
So to repeat the question is, now we're looking at AI when it comes to, actually drafting patent applications, prosecution, other aspects of the IP process, right? And what the effect is on everybody else. We're part of that, right? There's a lot of tools now for AI patent drafting. Full disclosure, my firm has an investment arm, and we have invested in Solve Intelligence, which is one of the tools that's being used right now. And you're right, that is making it easier to draft. AI is making everything easier, right? There's a few things. One is that it could be an arms race, right? That's what everyone says when it comes to AI. It's easier for you, but it's also easier for everybody else. But it also makes it easier for the patent office to then examine patent applications, right? So you're right, we might be flooding the patent office with more patent applications now because it's easier to draft. But perhaps, and this is starting to happen, the patent office is now also adopting AI to then get through that backlog faster too, right? So that's one way to see it. I mean, we know in equilibrium, we don't know in equilibrium what that's going to look like. But for now, it seems like there's going to be some form of an arms race. To answer your other question about when it comes to analyzing prior art, or even if you're in a relatively larger company with a lot of different ideas being generated, there are now AI tools that are looking at that as well, which is, imagine an AI agent that then is always scanning all your company conversations and emails and documents, and is making recommendations like, hey, I think this is something you should get a patent on. I think that one. Oh, this one is good, but might be too expensive. So people are working on that problem as well. Yeah.
Great, thank you.
Great.
So, thank you, by the way. This is fascinating discussion here.
Great.
So if I'm hearing you correctly, if I have AI helping me out, I should keep that a trade secret. Is that correct?
So you're saying if you use AI to help you invent something, you should keep it as a trade secret.
Well, I'll give you an example. So a lot of people are now using vibe coding. So that's AI developing the code.
Yeah.
If I come out, and vibe coding actually allows me to try a whole bunch of different things much more rapidly than I ever could have done before. And I find one thing that, oh, God, my goodness, this is going to make me a lot of money.
Yeah.
I just keep that a trade secret then. Well, or come up with the manual way to come up with the same results.
Yeah, that's a really good question. So there is a qualitative difference there, which is you are still coming up with the ideas, but then you're using vibe coding to accelerate actually implementing them and then evaluating which ones actually work and worth pursuing. That is still okay in the sense of you being an inventor on those ideas, right? Because the AI is simply a tool to help you implement it. It's no different than a professor coming with an idea and then hiring a bunch of lab assistants to help, build it, right? The difference, though, is what happens when you're vibe coding, and then the AI is actually coming up with solutions that you either would not have thought of or didn't come up with. Then that would be an issue, right? Technically speaking, according to the rules, no one would be considered an inventor on that IP. So yeah, the next best thing would be to keep that as a trade secret.
Okay.
And that's what we're seeing.
Okay.
Good.
Thanks.
I had a question about, I think there was a controversy about many LLMs like ChatGPT using copyrighted content that they just, like vacuum from the internet and build their own models. Even if the content was like, for example, some publications are available for free. You can download the PDF of the paper for free, but they use that freely available data in their training to train their models. So what's the kind of the law on that?
Yeah. So the copyrightability, but with AI basically being trained on a lot of material, especially copyrighted material, what are the issues when it comes to fair use versus copyright infringement? Right. That's the basic question. That's a huge issue right now. I mean, I see this talk on LinkedIn all the time. Right. All the copyright lawyers are very excited this year, right? Because they finally have something new going on when it comes to this. I mean, you're right here in Silicon Valley, right, where all of these lawsuits are happening, right, in federal court. So I think we're still in the beginning stages of that. I'm sure you may have heard the news about those rulings, right? But I think we're still in the early stages of that because the law is essentially still under development. Okay. Keep in mind that even though we think of patents as the one that is more technology-oriented, the most technology-oriented area of the law, right, by definition, copyright too had evolved over hundreds of years, also based on technology, right? For example, when the camera was first invented 200 years ago, there was actually controversy as to whether a photograph could be copyrighted, right? And then the law gradually evolved and changed, either explicitly, right, through statutes or shaped by case law, to then keep up with technology. And I suspect, and not just me, but other people in this industry as well, think that the law is of course going to copyright law is going to evolve to then take into account the rapid advances in AI. So we don't know what the solution is going to look like. We just have to wait and see.
Okay.
Have you seen startup companies trying to using AI to invalidate some of the existing patents and arguing, hey, this idea it can be generated by AI and it's really accessible and not that much unique?
So you're saying what are people using AI to invalidate other people's patents? Yeah. In fact, people have asked me which AI tools do that because they want to use them. So it is an issue. I'll be honest, I haven't used them myself. I just read about them, so I can't recommend any particular one. But I do know that people are developing AI tools for both detecting infringement, like building an AI agent that sees if anyone else in the world may be infringing on my patents, right? That's one. The other is, let's just mess with this other company that I don't like, maybe their competitor or whatever, and let's see which of their patents seem the easiest to knock down. And then you have an AI agent that kind of runs through that hypo. That is something that is happening. That is correct.
Any successful cases?
Not that I know off the top of my head. I just know anecdotally that people are trying it, but it might be a little bit too early to say. Yeah.
Thank you. I also have a question. For example, you use these foundation models, and AI is very good in pattern recognition. So you can do like protein folding, like millions of variations, and everybody using like similar technology. So in the future, do you think there might be a lot of conflicts because everybody is able to create, all these variations? Could be like science-related stuff, could be also design-related. And you can do now all these variations in seconds. So how is it then defendable, because everybody on the foundation using the same technologies actually?
Yeah, so you're basically saying if AI is able to innovate so fast and so easily, is the space going to be basically incredibly crowded, right? What's the point in even trying to innovate if I know that tomorrow an AI is probably going to invent what I just came up with?
Or is it even defendable? Whatever you are creating, is it even patent? You can have a patent on it, or is it defendable? Because everybody has the same technologies. Actually, everybody can iterate very fast. Yeah. All these variations, and it's very good in pattern recognition. It will always create something similar what already existed.
That's right. Yeah. So this goes back to what I was saying about an arms race, right? And you're totally right about that. Is that you can use AI to create better patents, but then someone else can use AI to design around your patent too. So it truly is going to be an arms race, at least in the near term. Medium term, who knows? So you can see the questions that I have here that, who knows 5-10 years from now, right? But at least in the next 1, 2, 3, 5 years, I think it's going to be an arms race, and it's just we're not yet in equilibrium as to like which side is going faster. I do know for a fact that people are basically copying other people's ideas that they see much faster than before, right? And it becomes a lot more difficult to then spend time and energy and money potentially going after these infringers. And then sometimes you just have to say, hey, you know what? Even though it looks like they're infringing my patent, I don't have the time and resources to go after them. I would just, do something even better, right? That seems to be what some people are doing. I'm not saying that that's what you should do, but it just seems like we're in this state right now. We're just not in equilibrium yet.
Yeah, thank you.
Yeah, thanks for coming. This is great. Another hypothetical, if you're building AI, like let's say an agent, right now the pace of innovation is going so fast, everything's pretty open. But as you think about like how you can protect your agent, are there patents, are there copyrights? Can you copyright the prompt for fine tuning?
Yeah.
Can you think about like trademarking the evals? Like what's out there today?
That's a good question. So we're actually putting together strategies around that exact issue right now. It looks like it's going to be a mixed strategy when it comes to this, right? Obviously, trademarks could protect your brand, and that's a totally separate question, right? And that's something where Rajesh mentioned in the previous session where it doesn't matter whether AI created your logo. That's okay. You can still get that as your trademark as long as it satisfies all the other requirements. You can still get a copyright on stuff that you've generated. Like suppose you came up with a list of prompts for something, right? You can get a copyright on that. That's totally fine. But remember that copyright protects something different from patents. Copyright protects the creative aspect of something, right? For example, computer code can be both copyrighted and patented, or at least the concepts behind that particular code. But it protects different aspects of it. If you're protecting computer code with copyright, that's more similar to protecting a book as a copyright, right? It's the expression of these ideas, right? But not the ideas themselves. Whereas if you want to protect the ideas themselves encapsulated by computer code, that's where patents come in, right? So when it comes to building agentic AI, there's now all these layers of abstraction, right? When it comes to doing that, we see so many tools that make it easy for everyone to design their own agents. If you come up with some kind of platform for building agentic AI that's novel and non-obvious, then you can get a patent on that. We've seen people, go in that direction right now. If you're one level up and you're saying, okay, what if, these tools exist for helping people make agentic AI, and you come up with a process, right? A structured process for other people to build AI agents. As long as this is novel and non-obvious, that could be patentable, right? Of course, if AI came up with the idea, then you can't, right? But if you came up with it, that's perfectly fine.
Thank you.
Great.
Okay. All right. Please give a round of applause to Stephen Ho. Okay, so we're going to be open until about 7 p.m., so please feel free to talk to Steve individually or network amongst yourselves. Thank you for coming, everyone.
Thank you.